Good morning, everybody. I'd like to begin by acknowledging the traditional custodians of the Australian lands on which participants in this webinar find themselves and pay my respects to their elders, past, present and emerging, and any other Aboriginal elders here today. And for our New Zealanders present, ana mana, ana re'o, ana karatanga, maha tena, koto katoa. I am Bronwyn Weir. I'm a lawyer with a long-standing practice in regulation and a strong commitment to supporting regulators. For the past 2.5 years, I've had a particular focus on building and construction professionals, having been commissioned with Professor Peter Shergold to look at compliance and enforcement in the building and construction industries by the Building Ministers Forum. I've also been a strong supporter of the National Regulators Community of Practice since its inception. So wearing both hats, I'm delighted to be facilitating today's webinar on regulating the professions. On behalf of ANZOG and the NRCOP, it's my great pleasure to welcome you all here today. The NRCOP is powering ahead with regulator seminar series at the moment, and edited recordings of the first 3 webinars are available on the ANZOG website, and registrations are open for the next 2. These are on why do people comply, which will look at international and Australian research on COVID-19 behaviours, and how do we know we're good at what we do, which will look at the perennial dilemma of measuring regulatory performance. There will be a slide with more information on those 2 seminars at the end of today's presentation, and you can also find that information on the ANZOG website. Some important housekeeping for today's session. So, as you know, the platform has changed from Zoom to MS Teams, but we are staying with Slido as our medium for the way that you, the audience, can ask questions and interact with the speakers today. You can also upvote questions that are lodged by others so that we know which ones have the most interest. So head to slido.com, and if you enter hashtag professions, you can start posting and upvoting questions immediately. Consistent with the previous formats, which seem to have worked well and we've had good feedback from the audience about, formal proceedings today will close at 11:45. But for those who have more time or who'd like to stay around for questions and answers, the panel and I will be here for a further 15 minutes until 12 noon if people are able to stay. I'm joined today by 2 outstanding fellow panellists. Roxanne Marshall-Shaw leads the Professional Standard Authority and serving professional standards councils and their mandate to protect consumers and professional services across Australia through improved professional standards and practices. Roxanne is a regulator with over 20 years' experience in performance, human rights and protective jurisdictions, and her experience has been developed through a variety of executive roles and statutory appointments in the ACT, Commonwealth and New South Wales public sectors. Roxanne is also a member of the Occupational Therapy Board of Australia, chairing its Registration and Notifications Committee. Roxanne is also the convener of the New South Wales chapter of the NRCOP and a member of the National Steering Committee. I also have today with us Jane Eldridge, and she is the New South Wales State Manager for AHPRA, the Australian Health Practitioner Regulation Agency. She's a new member of the NRCOP in the New South Wales chapter. Jane has worked across a spectrum of roles in the healthcare sector. She started her professional life as a nurse and a midwife, and later became an advisor to health practitioners in her role at the Medical Defence Union and Avant. She has worked as a legal practitioner for the AMA also in New South Wales, so she has a number of perspectives on regulating health professionals. Regulating professions has a long history in Australia and New Zealand, and there are varying views on how best to set up an occupational licensing regime. The variance often manifests itself in different models that can be created, which provide for self-regulation, co-regulation, or government regulation of occupations. To set the scene for today, I'm going to share a slide with you that talks about different models or represents different models in occupational licensing. So the first model that I'd like to show today is where we have government decision making, where government essentially is the governance arrangement is through government decision makers, so usually public servants, and it's those decision makers that set entry requirements and administer applications for registration. And then they also run the complaints and the discipline function, which is integral to occupational licensing. In those circumstances, the government regulator, of course, prosecutes those that are practicing without registration. If we move to a second model of governance, and this is probably one of the most popular models, is where an industry board is created to be the decision maker, and the board will have representation from the practitioners or professionals that it's regulating. Sometimes also legal reps or consumer representatives sit on those boards. And in those cases, the board is the decision-making body that sets entry requirements for licensing and runs a complaints and disciplines function. And often those boards will also have a power to prosecute those that are practicing unregistered. A third type of model is where you have either a government or a board as the key decision maker, but where that decision maker recognises industry accreditation schemes. So in this model, you will have the occupation being registered, we'll have industry bodies or associations which are quite well developed and have accreditation schemes. And in this third model, government recognises those schemes. So as a default, those schemes are really run by the industry associations in terms of applicants seeking accreditation, and the industries association manages that administration, which is then recognised by the government decision maker. In this third model, the government decision maker still runs the complaints and disciplines function and still prosecutes the unregistered participants. The fourth model is where we move away from government regulation into an industry association model. And this is where the industry association itself sets up and administers the entry requirements into the scheme, runs their own complaints and disciplines function to exclude members behaving inappropriately. And by and large, these schemes are voluntary. So there is no prosecution, for example, if people are operating and are not members of the scheme. The fourth model that I've shown on the slide reflects sometimes industry associations that are quite well developed at running a membership which has these features, but it also reflects a model that is run or operated through oversight of the Professional Standards Council, where they recognise a professional standards scheme. So you can see that across these four models, the involvement of government runs across a spectrum into co-regulation and then self-regulation, potentially with government oversight through the professional standards scheme that operates nationally in Australia. And so the involvement of the industry participants varies across these models. The other spectrum of difference between the models is, of course, again, around that independent oversight which is given to the profession by government, but also the input of technical expertise that is sometimes required, or not sometimes, but often necessary to really properly make decisions about professional conduct and whether there have been breaches of conduct or unprofessional behaviour. So in the earlier models, models 1 and 2, where you have heavy government decision making, there'll need to be a mechanism for that technical knowledge to be applied to the complaints and discipline function of that regulator. Now, recognising that this is quite simplistic, there are obviously more than 4 quadrants that you could have in each of these models in terms of the complexity of operating an occupational licensing system. The intention really of this slide is to to demonstrate the variance in models which are featured by the independent oversight, sometimes which is created when there is a lack of trust in the profession itself, so government steps in to perform that oversight and regulation function. What's interesting about these models, and certainly from my experience in the building sector, is that you can actually have the same occupations licensed or registered under one of these 4 different models across different jurisdictions. You can also have, even within a jurisdiction, different participants in the building sector, for example, being regulated through different models of occupational licensing. So, for example, in New South Wales, there used to be a board that was regulating certain types of building practitioners, but at the same time, the Office of Fair Trading, the government regulator, was managing the registration scheme for builders, for example. So it's definitely a governance decision that has to be made, which requires this important judgment about the extent to which the practitioners themselves or industry associations will participate in the scheme to provide some measure of co-regulation combined with government oversight. So that hopefully sets the scene for some of the things we're going to talk about today. And I will just turn that off. Before we move to the speakers and the Q&A session, I'm going to run a couple of Slido questions just to get some interaction with the audience here today. So hopefully you've managed to log into Slido whilst we've been talking, and I'm going to put up the first question for the Slido polls for today, which is just to get a feel from the audience of who here today works in a government body that regulates occupations. Great. So most of you. We'll keep this going if we can up to around 100 people. Whilst we wait for people to log into Slido. So the first Slido poll question, to get a feel for our audience: do you work in a government body that regulates occupations? And if you go to Slido, #professions, you'll be able to participate in this poll. Give a few more minutes for those numbers to come up and get everybody working on Slido. Okay, perhaps if we cut it out at 80, thanks, Mark. And we'll move on to the next question once we hit 80. Thank you. Second question for our Slido poll today. In a COVID-19 context, how do you think public confidence in regulators has changed? So you have a scale there of 1 to 5 effectively. Do you think that public confidence in regulators has slightly increased, remained about the same, or that there's been a loss of public confidence? So just confirming the question, in a COVID-19 context, how do you think public confidence in regulators has changed? And we'll cut that out there, thanks, Mark. So the overall impression from the audience is that there's a slight increase there in confidence. And the third Slido question for today: what do you think the most important feature of an occupational licensing scheme is? And this is not an exhaustive list, but myself and Roxanne and Jane were interested in the impressions of the audience around 5 features of a scheme and which of these 5 you think is most important. Whether that's disciplinary actions and outcomes, having appropriate qualifications and experience for entry, codes of conduct, complaints management, or compulsory insurance. Recognising that all of them are important features, but keen to get a feel from the audience as to where you think a bit of a heavy focus there on the gates to entry. Okay, thanks Mark, we'll cut it out there. So it seems that most of you think those gates to entry are a pretty important part. It's who we let in that determines how well the scheme might work, which of course raises issues about grandfathering and how you manage a new scheme or changes to a scheme that allow existing participants to remain in the sector. But let's perhaps reflect on that later. All right, I'd like to bring Jane and Roxanne in now and start with what might seem to be a pretty obvious question. We're talking about regulating the professions today. Roxanne, as our member from the Professional Standards Council, what makes an occupation a profession?
Thanks, Bron, and good morning to everyone on the webinar. It might be an obvious question. It's also a ginormous question. I mean, the whole PhDs are written around what makes an occupation a profession. But generally, I think there would be consensus that it's through social licence, and that the social licence to operate as a profession is earned, not granted. There's no wonderful government department that goes about granting recognition as a profession to occupations. It is through a compact between government, society and the occupation collectively that establishes a profession. And that is hard won and easily lost. I only think back to the regard in which bankers were held right up until the 1980s, and how quickly their credibility or legitimacy or trust was lost from the community. So it requires, through that social licence, gaining and maintaining legitimacy, credibility and trust. And for professions, that is built through acquiring and using a special cumulative body of knowledge and skill, through practice that is autonomous, through coming together or in service of a public good. In some professions, the commitment to do no harm, by offering impartial counsel, by adhering to a universal and distinctive code of ethics for the profession. And of particular interest to me and to the Professional Standards Councils, the feature of accountability, the accountability to peers, by creating and enforcing professional standards in order to protect consumers. We have all experienced, I expect, that a profession, practitioners have the well-being of their clients, their consumers or their patients in their hands, and can do enormous good and enormous harm. So they have in their hands the very existence of their clients or their consumers or their patients. They have their health, they have their financial position, they have their legal rights, or the safety of the built environment within which they're living in their hands. And I think that maxim that with great privilege and power comes great responsibility is at the heart of the regulation of a profession in the public interest.
So Roxanne, I guess from what you're saying and from what we know historically, professions are created by the professions themselves, distinguishing themselves, creating groups or associations and collaborations where they seek to distinguish themselves from others, perhaps providing the same service through qualifications and other things. But of course, over time, although professions historically have been created from within their own community, governments have stepped in to regulate those professions in a mandatory way. And this has become much more common, and it's a very common feature of Australian occupational licensing compared to, say, for example, the UK, where those industry associations still have largely a self-regulatory model. So we can see from the models that I showed on the slide earlier that we do have these different levels of government intervention. But given what you've said about how important it is for the profession to create its own parameters around its professionalism, does government stepping in to regulate a profession actually erode the ability of the profession to remain a profession?
Bron, I think that can have elements of self-fulfilling prophecy about it. Certainly, the ultimate goal of all regulation, whether it's command and control regulation by government, co-regulation or self-regulation, is to meet community expectations and reduce the risk of harm to the community. So where trust in the profession being able to do that slips, or where it's lost, then yes, it's more likely for government to increase the level of regulation in that occupation or in that profession. And you know, it's one of those experiences. You know, you look back to legal services in the 1980s, or in my experience, regulating disability services in the 1990s, or aged care services in the 2000s. There was strong community feedback that those services, those professions weren't operating with the level of transparency that the community expected, or addressing the harms that consumers were experiencing. And there were palpable fears that those practitioners were serving their own interests over their clients' or consumers' interests. And when that occurs, and when that trust and confidence in a profession, when their credibility comes into question, then government will step in as the regulator to ensure that consumers, clients, patients are protected in terms of the standards that those practitioners are adhering to. So yeah, I think if there's a loss of trust, if the profession does not hold itself to the community and demonstrate accountability to the community, then yes, government can step in. And then once that occurs, that can lead to further regulation and further step back from those commitments as a profession. So I think we do need to be vigilant in those circumstances and encourage.
Well, I think you're right, Roxanne, and what's happened in the building industry context is that the industry then turns to blame the government for its shortcomings and expect the government to fix the systemic problems and say that this is because government hasn't regulated us. So you see this sort of abrogation of responsibility by those groups that are supposed to be professions and have their own standing and in their own right. So I do think that is an example of where things can go wrong, and where that balance between government oversight and industry investment engagement in their own profession needs to be very carefully structured. Just turning now to more challenges of regulating the professions, I'd like to bring Jane into the conversation here, because the regulation of health practitioners in Australia underwent an enormous overhaul in a very short period of time in the 2000s, and I'm sure many of us, even if you weren't in that sector, were well aware of the changes and the overhaul to create a national scheme. Could I ask you, Jane, what are the unique challenges for regulating health professionals?
Thank you, Bron, and good morning, everyone. There are indeed a lot of challenges with regulating health professionals. And in regard to the National Registration and Accreditation Scheme, probably one of the overarching challenges is the fact that The mandate is to keep the public safe, and in that is ensuring that 16 professions with as many registration standards, so great complexity of registration standards, ensure that the workforce is safe. So that's probably one of the key. There are actually 740,000 health practitioners that are regulated by the scheme, and that in fact is 5.8% of the workforce in Australia. So the volume is significant and necessarily complexity. But I think probably one of the other challenges which is less obvious is the fact that we're dealing with health, and health is a big deal. Health is a big issue for everybody. The stakes are high. And whenever there is a decision to be made in respect of health, it is always going to be very challenging for all the parties involved. So that includes the practitioner, the patient, the health department, and also the regulator.
And how do you, in the context of health practitioner regulation, balance that essential need to have the health professionals involved and the consumers involved in the scheme?
From very early in the scheme, Bronwyn, the engagement of both health professionals and the public has been critical. So clearly, on boards and committees at both the national and a local level, the professions are obviously represented, as are the community. Early in the scheme, a professions reference group was established, and then later on in the scheme, a consumer reference group was also established. But beyond this, AHPRA and the scheme engage very widely with all stakeholders. I think it's fair to say that AHPRA seeks and invites comment. So we are sure to be constantly evolving because we are taking on board whatever the consumer perspective is, so that we can continually evolve to improve our regulatory decision-making process.
Roxanne, in advising professions that come to your organisation querying how they can set up professional standard scheme, how important is the role of consumer or customer in the setting up of a professional standard scheme?
Bron, our conversations with associations are around the centrality of the consumer and the public interest and the community's interest in being a regulator of the professional standards of their members. If we don't have consumers as the paramount consideration, what is it that is required to protect consumers? What is it that communities expect of our profession? Then the profession will be unable to regulate its members and to lead the behaviours that are required to ensure that consumers get the quality of service and the outcomes that they are entitled to from practitioners who hold the expertise, hold the ability to make a difference in their lives for the good, not for the worse. So we have many conversations with associations about how do you structure consumer perspectives in the design, in the implementation, in the oversight and in the decision-making processes of the association when it steps into that role as the regulator of the professional standards of their members. It has to be central, otherwise regulation serves no purpose. It is geared to change behaviour to serve the interests of the community.
And just moving on to another issue, and commonly I guess in my role as a legal practitioner, often defending decisions of decision makers in the context of disciplinary outcomes or refusal to register, those sorts of things. Sometimes I've heard, and I do think that the experience I've had is that the law is quite tough on regulatory decision makers in this space. You're judging or juggling the interests of the practitioner's livelihood, their reputation, with the need to make very careful and just decisions about the complaint that has been made, or potentially not letting them operate and practice or hold registration if it's a decision about that entry point. Roxanne, do you think the legal system is too tough on regulators?
Bron, I wouldn't say that it's too tough. I think it is tough, and I think it should be. Regulators need to be held to account as much as the practitioners that we regulate. And it is a testing obligation in a protective jurisdiction compared to a punitive jurisdiction. The public interest has to be paramount in all of the decision making that we undertake as professional standards regulators. So it does force us to invest in ensuring the decision making is robust, and it does force us to guard against risk aversion from having our decisions tested and taking the course of least resistance to avoid judicial criticism. But that path leads to, again, a loss of confidence, a loss of trust in the profession to be able to hold its peers to account. The decision making must be robust. The legal system is tough, but for good reason.
And Jane, in the context of health regulation, health practitioner regulation, do you think that the legal scrutiny affects the decision makers and the staff within the regulator in terms of how they approach decisions if they've had a decision overturned by a judicial review?
I think that's an interesting point, Bronwyn, and there are two aspects to this. One is about the fact that the regulatory decision-making process is very robust, and I think under the national law, there is the flexibility for the process to be constantly improved so that the rights of the public are balanced against those of the practitioner. So with regulatory principles at play here, every decision that's made by the regulator, whether it's in respect of a practitioner's registration or whether it's in relation to a concern that the public have raised about a practitioner, the process is so robust that there is the capacity to review the risk and assess the risk and apply appropriate response to that risk. I do think, though, in regard to the staff, that given the fact that the decisions that are being made are around health and are in some circumstances dire, particularly if it means a practitioner may lose their registration or their reputation is at stake, I think there's an intensity involved in the decision making, and I think the staff are affected by this or can be affected by this, particularly in light of the additional layer of occupational stress that they experience, which will include close media scrutiny, very close media scrutiny. I mean, often staff are dealing with very distressed and traumatised practitioners and notifiers. They may be dealing with practitioners who have attempted suicide. They're working in a very high performance environment. And so I think these pressures definitely impact the staff.
Mm. And just coming back to this issue of consumer confidence, and we can certainly are well aware of the loss of confidence in the building industry and very public attention on issues around combustible cladding and opal and mascot towers in New South Wales. And building practitioners have been regulated quite closely by government now for some time. And this has led to a lot of blame being laid on the government for the failures of the sector. Industry groups, and some of those which would characterise themselves as professionals, have been particularly harsh on government, claiming the failure to enforce ethics and competency has allowed a race to the bottom. And the building industry is not alone in that term of race to the bottom. And one of the responses from the building ministers has been to say to industry, well, how about you take responsibility for your own standards? And they've been directed towards the professional standards schemes operated by the Professional Standards or overseen by the Professional Standards Council, Roxanne. Is it counterintuitive in circumstances where there's been such a loss of confidence to ask the industry participants to be part of the solution, and to expect that they can be trusted to self-regulate through professional standards schemes?
Bron, I think it's quite the reverse. I think it's wholly intuitive that the profession should be asked to step in and step up, and it's a huge opportunity for an occupation to seize the day and race to the top. I mean, this is entirely within the control of an occupational group or an association to embrace. The occupations within the built environment have the expertise to know what the competence and conduct issues and risks are within their sector, and they could not be better placed than to be able to mitigate those risks and to address them. They have the direct access and influence with their peers, and they hear directly from their customers, from their communities every day. So are uniquely positioned to be able to bring that knowledge of their occupation, of their profession, and of the customer or consumer or client experience together, to be able to be responsive and much quicker than government to be able to solve problems in terms of standards. So I think this is a really unique time for the professions within the building industry. But I think there is a challenge, and that is that we know that it's hard to regulate. It's not something that you can choose to do overnight and suddenly you're well equipped to be able to run professional standard systems and lead a whole profession to be able to embrace that opportunity. So I think there are also opportunities to support that transition for the longer term through capacity building and perhaps looking at some co-regulatory measures where you might link occupational licensing and professional standard schemes. But the hardest part is going to be the occupational associations taking that leadership role and making that commitment, because it is a significant commitment and needs to be and there needs to be leadership to bring it alive.
Yep. I'm going to move us on to a question around COVID and our COVID environment, and go back to Jane, because we heard a lot at the start of the COVID restrictions about the need to create a surge workforce for the health industry. And I'm keen to understand how AHPRA managed to do that, to create that capacity, and bring back practitioners into the registration scheme, and how risks were managed around the parameters and the criteria for who was brought back onto the register.
Well, that's right, Bronwyn. We're facing a pandemic, but that does not mean that regulatory principles do not still apply and that the public must not still be protected. So that is still paramount, protection of the public. So it was a case of balancing supporting the surge workforce, but balancing that against potential risk to the public. So the way this was managed was considering possible regulatory risks around bringing back practitioners, and essentially the National Board and AHPRA, in conjunction with ministers, agreed upon a set of criteria where, for example, practitioners who had left registration or had ceased to practice in the prior 3 years could be included in a sub-register, but beyond that was perhaps a little too long. So also there was a need to ensure that the practitioner was not the subject of a complaint during that time. The sub-register, which actually contained 40,000 practitioners, was only ever to last for 12 months. So it was capped and potentially less if the pandemic ended sooner. It also, the initiative also brought in the health departments and employers into play to assume some obligations with meeting the checks and balances that maybe AHPRA was not in a position to make, given the urgency of the situation. But working together, collaborating with the departments, we did manage to compile a sub-register in a very short space of time.
Mm-hmm. And just sticking with the COVID-19 theme, Roxanne, what do you think the implications might be of, we've seen a number of the CPD schemes, for example, be adjusted to allow for online learning, and there's also been compromises to that that practical experience element that might be required as part of a standard scheme or a registration scheme. Do you think that will have an impact on skills and experience over time?
Bron, I think it will be how long those how long those adjustments are in place for will affect whether or not they reduce standards over time. You know, I think we base those CPD requirements on good evidence and good research that shows that a mix of continuing education modalities is necessary to keep people connected to their profession and to maintain their competence and conduct. So I think it's incumbent on us as regulators to monitor and to analyse and to be able to review those strategies, because we don't want to be the type of regulator that is the ambulance at the bottom of the cliff rather than the fence at the top. So I'd be worried if we lowered the fence to be able to respond to the pandemic and we didn't come back and check whether that had any inadvertent implications in terms of protecting consumers over the long term and into the future.
Okay, thanks, Roxanne. I'm going to go to a couple of questions before we hit our 45-minute limit there. So the most popular question is, what are examples of when community trust has been lost but resolved through government intervention? There seems to be a hint of scepticism in that, as to is it implied that government intervention can't bring back that trust? I wonder, Roxanne, whether you can think of examples of this.
Look, I think I'm just reflecting back to legal services and some of the issues that were bubbling away in the 1980s in terms of legal practice being a closed shop and clients not being able to access remedy and redress, and the response from government at that time was to move towards legal services commissioners being able to receive complaints and to bring a community or layperson's perspective and input to those matters. And I think we have certainly seen the legal professions standing rise since those days. So I think there are, and certainly in relation to, you know, looking back to some of the issues around aged care back in the 1990s, and what we're seeing in terms of the reforms and the confidence returning to disability care, and the ways in which government has stepped in to lift standards and to support confidence in the quality of the services being provided by the occupations and the professions involved in those sectors. So I think there are certainly examples where community trust has been rebuilt after a crisis. I think the difficult aspect is that it sometimes takes a crisis to be able to turn those corners, and I guess that goes back to the point I was touching on earlier around better equipping regulators to hear and understand community perspectives and concerns earlier and more readily in the regulatory process to be able to address and forestall those situations arising.
Okay, we're going to continue with questions through till midday, but before we do, it is now time for those who would like to leave the session to head off, and thank you very much for attending. You will receive an evaluation for today's survey, and as always, the ANZOG and the NRCOP welcome your feedback. Can we have the slide up, Mark, for the upcoming seminars, just to show people who would like to leave the session now what we've got coming? So why do people comply, and how do we know we're good at what we do? So for those of you leaving, please note that these are the next two sessions. They're running fortnightly on a Tuesday or thereabouts. So please, please register for those if they're of interest. I'll just move back now to Slido, and we'll keep going with some questions for the remainder of the session. So the next question is, how do we avoid the risks that regulations designed by a profession create unnecessary barriers to entry, reducing supply and keeping prices too low? And I guess this question also turns on that threshold question of at what point is it appropriate to require mandatory registration of a profession, and in doing so, does that have, I guess, market impacts that are not necessarily in the public interest? If I can paraphrase or supplement that question, I think it does go to a really important point. Jane or Roxanne, do you have a response to that question?
Ron, do you want me to take that first?
Sure.
Get
Yes,
please. Look, I think there are many interests served through regulation of occupations and professions, and certainly there are some interests, and perhaps they are still very much alive in some sectors today, which go to deriving benefits for the occupational profession in terms of competition and being able to manage competition through protection of title and creating those entry barriers. So I think we do have to be very careful and mindful as regulators involved in the policy responses to regulate occupations and professions, to be clear about what problem we're trying to solve, and to design the regulatory response as carefully and proportionately as we possibly can in relation to solving that problem. So for professional standards councils, just speaking from our current experience, our interest is in professional standards, not in granting recognition to professions or creating a marketing opportunity for occupations or professions, or stepping into that market regulatory space. But you know, I'll come back. I think it comes to the design process and being clear about what problem you're trying to solve and what unintended consequences might follow.
And I do think this is interesting. I guess if I can lend my experience from looking at the building sector, there's certainly an argument to say, why would we regulate trades, for example, as compared to a profession which you might characterise as architects or engineers, and they're all participating in that market. But what seems to have happened in that sector is that there's been regulation of certain participants in the chain, but not everybody. And part of the feature of the registration schemes has been the compulsory insurance requirement. So if you're not regulating the whole chain of practitioners in the sector, you're going to end up with gaps in terms of accountability through the holding of insurance. And so what we've seen is some jurisdictions registering right across the chain of supply of construction in the industry, and others only registering the builders or one end of that chain, and not necessarily the designers that are involved at the earlier stages of construction. And then what we see is that those that are holding insurance become the focus of accountability through legal claims and other things, and you get an unnatural skewing of legal outcomes for those practitioners, and the building surveyors are the ones that have had some publicity around that in building. So you do have to balance a whole lot of questions around who do you register, is what they do sufficiently risky to warrant registration, or are there other issues around chains of practitioners where you need to create an overarching scheme that enables that system to work, and for all of the duty holders in the chain to be accountable through registration. So it's a very complex scenario, and certainly there are policymakers out there who are, and there was a big push in the late 90s, early 2000s to actually deregister or remove registration requirements from a lot of professions as part of competition policy at the time. I don't know, Jane, whether you've got a comment to make on that as well, or shall we move to another question? How can professions rebuild trust, such as after a royal commission? That's a fascinating one.
That is a very interesting question, Bronwyn, but I think that they can. I think professions definitely can rebuild trust. I think with the Royal Commissions, it's such an exploratory process, I guess, for the profession. It does require them to reflect deeply upon how they've been conducting themselves. And I think that's a good thing, because I think they're not even, well, aware potentially of some of the criticisms that are being levelled against them. And once these are indicated, there is an opportunity for the profession to take on the recommendations and move forward. And that's a great thing for the public, because the public can then, I think, derive trust from the fact that they were willing to look in upon themselves and move forward.
And I think it comes back to some of the discussion we had earlier around them being part of the solution as much as they are part of the problem, and that self-reflection and change that's required. Certainly in the building industry, many of the industry associations are very focused on their members' interests, and what the building ministers are doing is really asking them all to have a more consumer and public interest focus, even those industry associations that are associated with trades or not necessarily professions. And there is a question in the Slido, questions about, you know, what is the difference between a trade, a profession, and occupation. When we have occupational licensing, we do seem to license a range of different types of occupations which would not necessarily be considered to be professions, and that's not, as you've said, Roxanne, something that is a criteria or that's bestowed upon a group of occupations. But I think it is important to recognise that we register occupations for, I guess, harm reduction or risk management at the same time as recognition of professional qualities that might exist within an occupational group. And I guess, Roxanne, you would agree, given that you have all sorts of groups coming to you that might not otherwise be traditionally thought of as professions.
Yeah, exactly, Bron. And it sort of links back, coming back to that question about the Royal Commissions, how do you rebuild trust? And I think two of the ways in which trust is rebuilt is through transparency and through credibility. So being transparent about what the profession or the occupation is doing in response to the concerns that have been explored in Royal Commissions, and responding to the harms that have surfaced through Royal Commissions honestly and openly through redress and through change within the occupation or the profession or the institution. You know, those institutional responses to be able to address those harms and prevent them from recurring. But then through demonstrating credibility, actually following through. The lofty words sometimes come easily,
Yes.
but it's the actions and being able to maintain faith with the consumers and clients of those services that the lessons have been learnt and that changes have been embedded in the way in which that occupational, profession or institution operates in the public interest, rather than, as you say, in their own interests, or as the ministers call on occupations in the built environment, to be able to put that public interest at the forefront of all that they do.
Jane, one for you, or one I'm going to couch for you. Will professions persist, given that they're not really they don't have exclusive knowledge anymore, because knowledge is so accessible to everybody, and we all know Dr. Google very well. I wonder whether this accessibility of knowledge and information means that we need registration less, or perhaps even more. Would you have a view on that, Jane?
Look, I do have a view on that, Bron, and my view is that, on the contrary, and I think my view stems from changes that I've seen over the years in working in and around health and health regulation, and probably particularly working with AHPRA for the last few years. That I think with registration, what I see is standards improving, increasing, outcomes improving. I see engagement, partnership with the public, and I think that it's a good and positive thing, and no, they won't desist at all.
No.
Can I add on to that, Bron?
Yeah, sure, Roxanne.
Because I think there's a lot of information available through all sorts of channels, but there's also a lot of misinformation, and I think professions will persist because it's not just the expertise that marks a profession. It's being able to apply that expertise in the interests of a client and to exercise judgment. So whilst information and misinformation may be easily accessible, that expert knowledge applied and the judgment utilised by a professional to be able to assist a specific client, I think will continue as a need well into the future.
Well, I have one here that I'm going to answer. In the building industry, how does the use of phoenixing erode professional oversight, and how might that be overcome? We've got just a couple of minutes to go, but in addressing that one, phoenixing is a major issue in the building industry and in other industries, but it does certainly seem to be of particular aggravation in this sector, and it's partly because the developers who are involved are not regulated in any jurisdiction, and they're often the ones accused of phoenixing or creating special purpose vehicles, which of course are legitimate legal structures. So this whole issue of phoenixing, whether it's legal, whether it's illegal, and the use of company structures for avoiding liability, when in fact that's what they're set up to do, is to limit liability, is a very complex one. There's a lot of work that's been done at the Commonwealth level around anti-phoenixing reforms, and I think what I would say is that it'd be good to see some increase in Commonwealth regulation through the corporations law, although interestingly I am aware that state governments are looking to how they can reform their schemes to try to address this as well. So there is a bit of a federalisation issue in our country in terms of whether the states will be seen to need to step into this breach and create regulation, but it certainly does undermine accountability. That's all we have time for. We've come up to midday, and I'd like to thank everybody for coming and thank the panellists, Roxanne and Jane. for a fabulous discussion, certainly from my perspective. So I hope we were able to interest all of those that attended as well. And there on the screen are the upcoming seminars. Thank you again for attending, and that wraps up this session. Bye-bye.